You gonna go, Echo? Okay. All right. Okay, thank you guys for joining us. You guys all hear me okay? It's the first time I've had one of these things attached to my head, so if I'm too loud, let me know. Thank you for joining us here today. My name is Jay Turner. I am the Director of Sunshine Law Compliance at the Attorney General's Office. I'm actually on my way out of this position. I'm taking another position in the administration, not in Sunshine Law, and Brandon Roberts, who is here with me today, will be my replacement at the AG's office, hopefully sometime in the very, very near future. A little background on myself. I am originally from Southern California. Please don't hold that against me. I grew up in San Diego. Both of my parents are retired highway patrol officers, and I spent most of my career as a state parole agent and a securities fraud investigator before moving to Missouri in 2015. Came to work at the AG's office, working on both civil and criminal cases. In 2017, I was promoted to our public safety manager position, and the Attorney General's office is a public governmental body, so we have sunshine law responsibilities. And one of my responsibilities in that role was to take in requests for people requesting information on our criminal investigations and our criminal prosecutions. So I would go through those records, I would determine what was open, what was closed, what was responsive, what wasn't, and providing those records to people. So I had about 6 or 7 years of hands-on experience with the Missouri Sunshine Law before moving into this position in February of 2023. And in this role, in addition to traveling the state and doing these types of presentations, our unit is also the one that investigates alleged violations of the Sunshine Law by public governmental bodies in Missouri. So if someone were to file a complaint against your particular public governmental body, our office would be the one, or our unit would be the one that investigates that. And please forgive my voice, it's finally started to go. I do a lot of these presentations, and saying public governmental body 5,000 times in a presentation is throwing my voice out. So if I say PGB, I am referring to a public governmental body. A little disclaimer here, everything we're going to talk about in this presentation is not meant to be legal advice either by myself or by the Attorney General's office. Full disclosure, neither Brandon and I are attorneys. Our role is more investigator. We can give you guidance, we can give you best practices, we can point you to certain sections of the Sunshine Law that might be able to answer your questions, but we can't provide legal advice. In fact, Chapter 27 of the Missouri Revised Statutes talks about who the Attorney Generals can provide legal advice to. And by law, we can only provide legal advice to state agencies, so the Department of Corrections, the Department of Mental Health, Department of Health and Senior Services, organizations like that. I like to make sure I mention that in the presentation, because a lot of times local officials, local public governmental bodies, private citizens will call our office asking, hey, is this record open or closed? Can they close this meeting? And that's just not a question that our office can definitively say yes or no. Like I said, we can give you that guidance. We can point you to sections of the Sunshine Law that might be able to answer your question. But the only person that can answer that question for that particular public governmental body is the attorney for that body. Our office cannot make that definitive answer for you. This is a quote that I came across that I think sums up what the Sunshine Law stands for. Democracies die behind closed doors. When government begins closing doors, it selectively controls information rightfully belonging to the people. Selective information is misinformation. I'm sure everyone here has heard of FOIA, or the Freedom of Information Act. FOIA is actually a federal law that applies to federal government agencies. It does not apply to the state of Missouri. So you may receive a public records request where someone says, I'm making this records request pursuant to FOIA or the Freedom of Information Act. If you do receive a records request that incorrectly references that law, but you can interpret that records request as being a records request, you do have to treat it as a public records request. When people make that FOIA request to a Missouri agency, what they are essentially making is a Missouri Sunshine Law request. And the reason I like to make that distinction is because we have had public bodies that have said, well, we received this records request, and they said they wanted these records pursuant to FOIA. FOIA doesn't apply to us, so we didn't respond. And that's not something you can do as a public body. If you can interpret something as being a public records request, regardless of the law that that person invokes to get those records, you have to treat it as a Missouri Sunshine Law request. So what exactly is the Sunshine Law? So the Sunshine Law is the public policy of the state of Missouri that all meetings, records, votes, actions, and deliberations of PGBs are open to the public unless otherwise provided by law. The Sunshine Law shall be liberally construed and its exceptions strictly construed to promote this public policy. So basically what this means is all meetings, records, votes, actions, and deliberations of public bodies are presumed to be open. They are open by default. If a public body is going to close meetings, records, etc., they need to have a legal reason to do so, and they need to provide you what section of law authorizes them to do that. And you'll notice we have a legal citation and a page number on our bottom right-hand side. We actually have two different types of booklets. We have a physical Sunshine Law booklet, and we have one on our website as well. We meant to bring those with us here today, but they're in the process of being reprinted. There have been some additions that we need to make to our booklet. So they're currently in the process of being printed. At the end of this presentation, we will have an email address that you can, if you want to get copies, you can send us an email. We're keeping track of a spreadsheet of who needs these booklets. But right now you can access our electronic version on our website. And some people prefer a hands-on physical booklet. Some people prefer the electronic booklet. Personally, I like the electronic booklet because if I'm looking into a complaint, I can do Control F and I can look for keywords in there where you can't really do that with a booklet. But both of those are available for you. And this slide, the takeaway for this slide is basically the public business is the public's business. So who does the Sunshine Law apply to? So it applies to Missouri public governmental bodies. That includes municipalities, such as cities and villages. It applies to county. It applies to, I don't know if that's me, or it applies to police departments, special districts, and committees. There was a study done a few years ago by the website governing.com that looked at public governmental bodies across the United States in relation to population. And the state of Missouri actually has almost as many public governmental bodies as the state of New York, and they have 3 times our population. And the reason for that, Missouri has a lot of special districts. We have ambulance districts, fire districts, library districts, taxing districts, water districts, sewer districts. I think last count there were about 5,000 roughly special districts alone in Missouri. Sunshine Law also applies to committees. So say, for example, a city council or a county commission appoints a budget committee to study the budget. Because that budget committee was created by and responsible to a public governmental body, being that parent governmental body, that city council, that committee has Sunshine Law responsibilities just as that city council does. And we will talk about what those specific requirements are later in this presentation. So the Sunshine Law defines a public governmental body as any legislative, administrative, or governmental entity that is created by the Constitution of Missouri or the statutes of this state, that's the revised statutes of Missouri, the RSMO, or by order or ordinance of any political subdivision or district. The last part of this line, by order or ordinance of any political subdivision or district, is basically what gives a public governmental body the power to create another public governmental body. So that's essentially what a city council or a county commission is doing when they create a budget committee or a parks and rec committee or other type of committee that reports to that parent public governmental body. So I mentioned about committees, but the Sunshine Law also applies to subcommittees or advisory committees. So say that budget committee decides that they need to create a subcommittee to study specific aspects of the budget. So now you have that parent governmental body, that city council or that county commission. You have a budget committee, and then you say you have a salary subcommittee or a parks and rec committee. Because that subcommittee was created by and responsible to a PGB, that subcommittee is a PGB in and of itself. It would also apply to a situation where a PGB creates an advisory committee. Say your city or your county commission creates an advisory committee of private citizens they want to build a new police department, they want to build a new health department. So they create an advisory committee of private citizens, not elected officials or not public employees, to study this issue and report back to the city council or that county commission. That advisory committee is a public governmental body for Sunshine Law purposes. We've recently had, not recently, but we've had issues where somebody's trying to get access to an advisory committee, and the public governmental body has said, well, this is an advisory committee of private citizens. It's not composed of public officials or elected officials, so it's not a public governmental body. And that assessment is not correct. It matters who appoints the advisory committee and who it is responsible to. So who is not covered by the Sunshine Law? So I don't know what our numbers are for last year, but for 2023, we had about 600 complaints, Sunshine Law complaints across Missouri for alleged Sunshine Law violations. Some of those complaints, the Sunshine Law did not apply. And examples of that would be private entities, so Subway, Target, Walmart, private businesses, private organizations, not subject to the Sunshine Law. Yes, we do actually get Sunshine Law complaints against Walmart. Homeowners associations and property owner associations, private organizations not subject to the Sunshine Law. I think that people think that because those entities have meetings, they take minutes, they post notices, that they must be a public governmental body, and they're not private organizations. Non-Missouri governmental bodies, so this would be federal agencies or agencies based out of state. The Missouri Sunshine Law only has jurisdiction over Missouri public governmental bodies. Judicial entities when not operating in an administrative capacity. So the courts have administrative responsibilities just like any other PGB. They have budget committees, they have administrative committees. Those types of situations, the Sunshine Law would have jurisdiction because they're operating administratively. If the complaint or the request for records has to do with a judicial function, so it's a court case, things off of casement. Generally speaking, the Sunshine Law does not have jurisdiction over the courts operating in a judicial capacity. The courts actually have their own rule that deal with records requests and complaints that have to do with public records held by the courts, and that's Missouri Supreme Court Rule 2. So if we get a complaint that has to deal with records from the courts, from a court case, a civil case, a criminal case, generally speaking, we have to close out that complaint and refer them back to the courts to have that, either that request or that complaint addressed to Missouri Supreme Court Rule 2, because the Sunshine Law does not have jurisdiction in those cases. Nonprofit corporations. So the vast majority of nonprofit corporations or private organizations, 501c3s, 501c4s, they're not public organizations. There is a very narrow area of the Sunshine Law where an entity could be considered what's called a quasi-public governmental body, a quasi-PGB. Prior to 2023, there was very specific criteria that an entity had to meet, and it was, generally speaking, it was a first benchmark, had to be organized under specific chapters of Missouri law, which was 352, 353, and 355, I believe. If it met that benchmark, it had to meet the second benchmark, where that organization's primary purpose, it couldn't be a subsidiary purpose or an ancillary purpose, its primary purpose, identified in its Articles of Incorporation with the Secretary of State's office, its primary purpose had to be to enter into contracts with a public governmental body. In 2023, there was a gentleman by the name of Mr. Malin, M-A-L-I-N, who was trying to get records from an organization called the Missouri Association of Task Forces. And the Missouri Association of Task Forces said, well, we're not a PGB, we're not a quasi-PGB, we don't have to give you these records. Mr. Malin disagreed, and he filed a lawsuit against this organization. When the court actually looked at that particular organization, not only did the court hold that it had to meet those two benchmarks I mentioned previously, but there were other things that an entity had to meet, other criteria. I think it was 4 or 5 different additional things that they had to meet. One of those had to do with who appoints the members of that board, who they're responsible to. Are they responsible to a public governmental body, a city council, a county commission, or a certain amount of their board members have to be public officials? Does the board control the operations of the organization? All these things came into play with identifying whether or not this Missouri Association of Task Forces was a quasi-PGB. At the end of the day, the court ended up holding that that organization was not a PGB or a quasi-PGB. Mr. Malin disagreed, and he filed a lawsuit, or he appealed that to the appellate court, and the appellate court actually upheld the lower court's ruling, saying that they correctly held that it was not a PGB or a quasi-PGB. So now I think a lot of organizations that previously may have been considered a quasi-PGB are no longer considered a PGB. Did you have a question?
Yes. It seems like there are multiple associations of like the county treasurers, the county commissioners, at the state level. What form do they typically take? Do they qualify as sunshine?
So things like the Missouri Treasurers Association or the Missouri Clerks Association, generally speaking, and probably not too much to deal with that, or it has to do with that Malin decision, those organizations are likely, I'm not gonna say definitively because I can't make that determination, those are likely not PGBs or quasi-PGBs. Because even though those are organizations that, clerks and treasurers can join, the county clerk's office, they don't control what that organization does. Another thing that was very interesting that was identified in the mail-in decision is that the funding for an organization doesn't dictate whether or not it's a PGB or a quasi-PGB. In fact, there may be situations where a nonprofit is completely funded by public funds. That alone is not enough to bring that organization under the umbrella of the Sunshine Law. Most individual employees or board members. So the Sunshine Law applies to records that are retained by or of a public governmental body. They don't apply to a public employee's personal effects, their personal records. I put that bullet point in here. We had a complaint that was filed by a member of the public that was trying to figure out what the salary of a presiding commissioner was. But instead of submitting his request to the custodian of records for the county where that presiding commissioner served, he submitted his request to the presiding commissioner himself and wanted the commissioner's personal bank records. Well, obviously the commissioner's personal bank records are not retained by the body, so we were able to close that complaint. But one interesting aspect of that complaint, and we'll discuss, I did mention that all public business is presumed to be open. You have to have a legal reason to close it. A majority of those reasons for closure are contained in the Sunshine Law under 610-021. There are 26 reasons why an organization, a public body, can close media records, etc. One of those subsections is subsection 13, which deal with the personnel records of a public governmental body. So if somebody made a request for the personnel records of a public employee, the public governmental body can likely close those personnel records. However, there are 4 things that a public body cannot close under the Sunshine Law, and that is the name, title, length of service, and salary of members of a public governmental body. So if that member of the public had simply made that request to the custodian of records for the county, the presiding commissioner's salary is something that the body could not close under the Sunshine Law.
Would you repeat those again? Name, title?
Name, title, salary, and length of service.
Thank you.
So section 610-028 of the Sunshine Law is the section of the Sunshine Law that requires every public governmental body to have a Sunshine Law policy in place that is open to inspection regarding the release of information on any meeting, record, or vote. So if you're a PGB in Missouri, you are required to have a Sunshine Law policy by law and a custodian of records named by law. That Sunshine Law policy can be as detailed as you want it to be. So our office actually recommends that include information such as when your meetings are held. So if you have meetings on a particular date at a particular time regularly, put that in your Sunshine Law policy. Your procedures for searching and producing records. Every organization is different about how they go about searching and copying records. Put that in your policy. It's a lot more transparent for members of the public. How your fees are calculated. 610-026 of the Sunshine Law talks about your fees, what you can charge. While there are some requirements for what you can charge as far as the maximum that you can charge for certain items, it's helpful to, everybody's going to have different about how they calculate those fees. So put that in your policy. Include details regarding who the Sunshine Law policy applies to. This generally is for situations where you have organizations like the City of Kansas City, City of St. Louis, St. Joseph, Springfield, where you have multiple Sunshine Law policies. The city clerk's office might have one policy. There might be a separate Sunshine Law policy for the health department, another one for the police department. Where in other jurisdictions, smaller jurisdictions, you might have one Sunshine Law policy that applies to all organizations within the city. And the reason it's helpful to put that in your policy, who it applies to, if a member of the public is reaching out to get records from your police department, they may be reaching out to the city clerk when they need to contact the police department directly, whereas in other organizations, the city clerk might be the custodian for the police department as well. So if you put who that policy applies to in that policy, it's a lot more transparent. If you don't already have a Sunshine Law policy, we actually have a sample one on our website. It's in the form of a resolution. You can kind of adopt the language in it for your particular PGB. We also have a records request form. It's a very generic form. Members of the public can use that form to request records from any PGB in Missouri. A lot of organizations have actually taken that form and adopted it specifically to their PGB, made it available to the public on their website or in their office or on their Facebook page, and they're welcome to do that as well. Okay, let's talk about public meetings. So the Sunshine Law defines a public meeting as any meeting of a quorum of a PGB that is subject to the Sunshine Law at which public business is discussed, decided, or public policy formulated. And those meetings can take place in person, they can take place electronically via email or text, they can take place via conference call, or they can take place via online chat or message boards such as Zoom, WebEx, Microsoft Teams, Google Meet. So those are the two things together that constitute a public meeting. A quorum is present of that body, and public business is discussed, decided, or public policy formulated. There is a misconception by not just PGBs, but members of the public as well, that if a body gets together with its quorum, and as long as they don't take any votes, but they just discuss public business, that's not considered a public meeting, and that's not correct. The two things that would constitute a public meeting is your quorum is present, and you discuss, decide, or formulate public business. Public meeting also the term shall include a public vote of all or a majority of members of a PGB by electronic communication or other means conducted in lieu of an in-person meeting. So I put this slide in here. I was training a organization, a public body down in the southeast part of the state that I'm not going to name. And this body had said, well, sometimes we get together for our meeting and we'll review all the information, and then we realize we don't have all the information to make a decision. So we'll adjourn our meeting, our clerk will go up, she'll gather additional information, email it to board members on our own, we'll review it individually, and then we will email our vote to the clerk. And I said it's very likely that the courts would interpret that as a violation of the Sunshine Law. Because while you're giving members of the public the opportunity to participate in the discussion, you're not giving them the opportunity to participate in the vote. So in that type of situation, you would need to repost that meeting at least 24 hours in advance with the tentative agenda to give the public the opportunity to come back and witness that vote in a public meeting. So what is not considered a public meeting? So the term public meeting does not include an informal gathering of members of a PGB for ministerial or social purposes when there is no intent to avoid the purposes of the Sunshine Law. And this slide comes out of this court case, Colombo v. Buford, where a body had gotten together for a social event. It was a Christmas party. And there just happened to be a quorum of the officials present at this Christmas party. And during this party, a spontaneous discussion came up about employee morale. What can we do to improve the morale of employees within our organization? And the public officials were throwing ideas back and forth. Members of the public joined in on the discussion. And later on, somebody found out about this, and they said that this was a public meeting. It wasn't posted 24 hours in advance. There was no tentative agenda. And when the court looked at that particular gathering, they noted that all 5 of these bullet points were not present. The event was totally unstructured. Nothing was gathered into order. People didn't take turns talking to the entire group. There were no trappings of what could be considered an official public meeting. However, the court was very careful to note that if any one of these 5 bullet points had not been present, or if that body had gotten together under the guise of a holiday party but really intended to conduct public business surreptitiously, it could have been held to be a public meeting under the Sunshine Law. But it wasn't. It was a holiday party. So we just like to remind public bodies that if you happen to be together for a social event, there's a misconception that when a body gets together with its quorum at any point, even if they're just going out to dinner together, that constitutes a public meeting. And that's not the case. The 2 things that constitute that meeting are a quorum is present and public business is discussed. So if you happen to be together in a social event with your quorum for a holiday party or whatnot, avoid discussing any type of public business so you don't wade into that gray area. It's just a lot cleaner if you don't make that mistake. So types of public meetings. Back in my home state of California, we refer to closed meetings as executive session. I've noticed that some bodies will have special sessions and work sessions, and that's totally fine if you want to have those meetings with those special designations. But make sure to preface each one of those meetings by whether or not it's an open meeting or a closed meeting. So it's an open special session, it's a closed work session. And the reason that's helpful is those are the only 2 types of meetings the Sunshine Law defines. So it's easy for you as members of the public to know whether it's an open meeting or closed, to know whether or not you can attend. It's easier for members of that public body to know whether it's open or closed, because certain things may not want to be discussed in open versus closed, and the rules are a little bit different. And if our office is looking into a complaint and we can easily tell what type of meeting that is, the rules are a little bit different depending on whether it's open or whether or not it's closed. Last year I was investigating a complaint where the public body, again, not going to name, for the past 20 years, in every meeting they had, never differentiated open versus closed. They were using executive session, work session, special session interchangeably. And it was very hard to differentiate which was actually an open meeting and which one was actually closed. And when we spoke to the clerk about this, the clerk said, well, I've only been here 5 years, that's how I was trained. And just because somebody's been doing something a certain way doesn't mean it's the correct way. So we need to make sure that if you're having any type of public meeting, you preface it by whether it's open or whether it's closed. Yes, ma'am.
Back on the 24-hour rule, is there any exemption for emergency meetings where you have to get together by phone or something to make a decision that would otherwise peril the structure or the community? Or
So we are going to talk about that in the slides coming up. So, and actually we're moving into our public meeting notice requirements right now. So if you have a public meeting, you have to post notice of it, and that notice must include the time, the date, the place of the meeting, and a tentative agenda. The statute specifically says that your tentative agenda has to be reasonably calculated to advise members of the public of the matters to be considered. So if you have something that you even reasonably anticipate is going to come up in a meeting and you're going to want to talk about it, put it on your agenda. And if that meeting is being conducted by telephone or other electronic means, include the location that the public may observe or attend that meeting. So if it's an in-person meeting, the first 4 bullet points are required: time, date, place, tentative agenda. If it's a electronic meeting, it's a Zoom, it's a WebEx, or if it's a conference call, all 5 of those bullet points are required. That notice that we just talked about must be posted at least 24 hours in advance of all public meetings, both open and closed. The notice must be posted in a prominent place that's easily accessible to the public. And weekends and holidays do not count towards that 24-hour period. So say, for example, if your meeting is being held on Tuesday at 5 p.m. and the Monday before was a holiday, you would need to make sure that you posted notice of that meeting no later than 5 p.m. on that preceding Friday. Location requirements. Your meeting must be held in a place that is reasonably accessible to the public, and it has to be in a place that is sufficient size to accommodate the anticipated attendance. So if you have something on your agenda that you know is a hot button issue, you know it's going to draw on a lot of people in your community, make arrangements to hold that meeting at a larger location. If you end up needing that space or renting it at that space and you don't need it, then there's no harm, no foul, right? But if you have something you reasonably could have anticipated was going to be hot button and you didn't make those arrangements beforehand, that's when you wade into that gray area when it comes to the sunshine law. So the things I talked about before, the 24 hours in advance of a public meeting, a tentative agenda that's reasonably calculated to advise members of the public of the matters to be considered, a place that is reasonably accessible to the public, and a place that is of sufficient size to accommodate the anticipated attendance. Those 4 things are the things that the Sunshine Law refers to as the normal requirements of the Sunshine Law. But there may be situations that come up that fall outside of those normal requirements. You have to have a meeting in less than 24 hours. You have something that pops up that you need to add to your agenda and it can't wait. There's a place you have to hold your meeting in a place that's not reasonably accessible to the public or not of sufficient size. If one of those situations comes up, the Sunshine Law does allow for it. And it's 610-020, I think it's subsection 4, and we refer to that as the emergency or short notice exception. So if a situation pops up where it falls outside the normal requirements, one of those 4 things that I mentioned, you're still going to want to make sure that you post notice of that meeting as soon as practical, and you state in your minutes why it was necessary that it fell outside those normal requirements. So I'll give you a couple of examples of things that I found that could potentially be justification for an emergency or short notice meeting. You had a flood at City Hall, and you had public records that were in danger of being damaged, and the body needed to make a decision on where to move those records to. Or there was a flood at City Hall, and you normally have your meetings there, but you couldn't because it was flooded, so you had to move it to another location. Or say there was a grant deadline, the city had been given a grant, and you needed to make a decision on where to move those funds to, and if not, you were gonna lose those funds. Those are examples of something that could fall into that emergency or short notice exception. And a good rule of thumb, potentially for the 24-hour rule and adding things to your tentative agenda, is if something comes up in that less than 24 hours and you want to add it to your agenda, look at the issue. Can this issue wait 24 hours in order to be in compliance with the statute? If it can, the best practice is then just to wait and have the meeting within that 24-hour period. If it can't, it's like, nope, this is an emergency, we need to talk about this at this meeting. That's when you state it in the minutes so that it's listed in the minutes and there's justification for having that meeting. Another exception that came up not too long ago that I also wanted to point out was a public safety exception for a short notice meeting. Back in January of last year, we had those storms where we had trees and everything covering roads. There is a smaller jurisdiction in the southeast part of the state where their board of trustees can't make decisions after hours or on weekends without the approval of their board of trustees. And so when you had trees and items, debris covering roads, they needed to be able to authorize their public works folks to clear out those roads. They still posted as soon as practical. I think it was about 9 hours before their meeting, and they stated in their minutes why that meeting was necessary on such a short notice, because it was a public safety matter. Did that answer your question about? No? Did you have another?
So, what if it is a phone call? I mean, it's such an emergency that the head of the unit would call and say, can I do this? It's outside of my authority without the board approval, and it has to happen right away without some instruction.
So,
I mean, we post it, but is it, yeah, how do you deal with that?
so is this just one individual calling one member of the board, or is this the board planning on getting together to have this discussion?
Well, they're getting together asynchronously. Is it okay to get together asynchronously to make a quick decision? So, a person in the agency calls the board members and says, do I have approval? Yeah.
I can't say yes or no, that would be a decision for your attorney to make, but I would say that if you have to have that emergency meeting and it can't wait, still post it as soon as you can, practically according to the statute, and state in the minutes why that meeting had to take place on an emergency exception.
Yeah, I mean, that makes sense to me.
Yeah. Because there are those things that are gonna pop up where it is a legitimate emergency. We've had situations where someone's like, well, we just didn't want to discuss this next week, so we just figured we'd talk about it today. That wouldn't really fall into that emergency or short notice. It has to be a justifiable, like this needs to be discussed now. People's lives are gonna be in danger, money's gonna be lost, property's gonna be damaged. There has to be an attainable issue. So I mentioned that the tentative agenda has to be reasonably calculated to advise members of the public of the matters to be considered. And unfortunately, in the 51 years now of the Sunshine Law, it was passed in 73, there haven't been any court cases that have further defined what that means. So reasonably calculated to advise members of the public of the matters to be considered is all the Sunshine Law says about that. So on the left side here, we have a potentially insufficient agenda versus our right side, which is likely sufficient. And we use words like potential and likely because even our office can't say definitively, yes, there was a violation. The only entity that can make that determination that yes, a violation occurred or no one did not is a court of law. We can use the words likely or potentially, but we can't say definitively. So on the left side here, we have our potentially insufficient agenda, which listed under our unfinished business is budgets and park permits. Two things that seem pretty innocuous, probably not going to draw a lot of attention. But on the right side, if that budget has to do with funding for your police department, and those park permits have to do with a New Year's Eve fireworks display where people have children and animals at home, it's probably going to draw a little bit more scrutiny than the one on the left. Again, the one on the left is not necessarily a violation, but you cut down on the potential for ambiguity or questions if you just provide as much detail as possible in your tentative agenda. There is currently right now, I mentioned that there hasn't been a court case that had defined tentative agendas in more detail. There is currently one pending before the Western District Court of Appeals down in the Kansas City area. It has to do with a fire protection district, where their fire protection district, at every single meeting, they were adding things to their agenda that wasn't initially on their agenda. So, and this was happening over multiple years. So if a public body is adding something to its agenda at every single meeting over these years, was that agenda truly reasonably calculated to advise members of the public of the matters to be considered? Or were they just adding that because they knew there'd be less public scrutiny because it wouldn't be out on their agenda? I'm not making a judgment call on that one way or the other. Our office is not actually a party to that lawsuit. However, we did write an amicus brief to the court asking them to provide more detail about what has to be in a tentative agenda, because we do get a lot of complaints on tentative agendas, and unfortunately, because that reasonably calculated exception is so ambiguous, it's not really something we can take an action on unless there's something definitively that we can see. And I'll give you an example of that, something that did happen last year. There's a public body in the southern part of the state, again, that I'm not going to name, that even on the left side, we have unfinished business and we have 2 subtopics. But this public body was using unfinished business to discuss anything they'd ever discussed in a public meeting, regardless of how long ago that happened. And one example of that would be in August of 2023, they were discussing funding for their police department. And they decided that they weren't going to bring it up again. They didn't discuss it until October of 2024, more than a year later. And on their agenda, they just put unfinished business. There was no subtopics, there was no funding, there was no police department, there was no police department budget. So if you're a member of your community who cares about police funding, how are you supposed to know that your city council or your county commission is going to be discussing that topic? So in that particular case, we did find that that was a likely violation of the Sunshine Law, and that body actually went through Sunshine Law training as a condition of closing that complaint. And I'll say I've been doing this job for about 2 years, and I would say that a vast majority, I won't say all, but I will say a vast majority of complaints that I've reviewed are usually lack of understanding. The Sunshine Law is 51 years old, and it's so, if you've ever read it, it can be confusing about what's open, what's closed. And we can go in and we can train a public body today. Next week, we might have an election and there's a whole new board members. So with so many public bodies in Missouri, and there being 4 people in our unit, it's a constant struggle to get out the training. And unfortunately, the Sunshine Law doesn't give our office subpoena authority when it comes to the Sunshine Law. So a lawsuit usually is our usual, if we have to go, well, it'll be a lawsuit before it is anything else. So we try to do things with training before we advance to that level, because a lawsuit is a lot of public funds, it's a lot of time and resources. So we try to handle things on that training level before it gets escalated. Recording meetings. So the public body shall allow members of the public to record all open public meetings, both audio and video. The body is allowed to establish guidelines regarding the recording process. We don't want people walking up and sticking a cell phone or a camera in a board member or commissioner's face. So a body can establish reasonable guidelines regarding the recording process, but they can't prohibit members of the public from recording an open public meeting. One of the questions I got recently, well, what if we record our meetings live on YouTube? And people can either watch that meeting live or they can go back and watch it later. As a matter of transparency, as a public service, we recommend that you do that. But even in those situations, you still can't prohibit the members of the public from recording an open public meeting. There's also no requirement that they notify you that they're going to be recording. So they don't have to let you know in advance that they're going to be recording if it's an open public meeting. And by the way, feel free to take pictures of these slides. I'm going to email a copy of it to Echo, and there's a email address that we'll have at the end of this that we can email you guys copies of it. It's not closed, it's an open record, so but we can provide that to you guys as well. Closed meetings may not be recorded without the permission of the public body. So that right to record meetings does not extend into closed meetings. So a lot of times a board will like to record their meetings for posterity or for minutes. If you're going to do that, we recommend that you take a vote on the record to specify who's going to be recording and by what method they're going to be recording, so there's no question later on that recording was authorized. Because the not recording public meetings is not just for members of the public, it's also for sitting members of that board. So just because you're sitting as a member of that board doesn't give you the right to record that meeting. It still needs to be authorized by the public body. In fact, there was a case not too long ago where a sitting member of the board recorded a meeting surreptitiously, and and then tried to use that against another board member, and there was actually a criminal complaint filed against that person. Best practices for all public meeting notices. Make sure you post your meeting notices and agendas in an area that is easily accessible to the public even after business hours. And consider posting more than one physical notice. So if you have a public meeting, regardless of whether it's an in-person meeting, if it's an online meeting, if it's a conference call, a physical posting of that meeting, the notice with the tentative agenda, is required for every type of meeting. Only one is required. You can definitely post more notices in multiple places to let people know that you're having that meeting, but one physical notice is required for all meetings. That agenda and that notice must be accessible even after business hours. So say, for example, that the meeting was being held here, and the notice in the tentative agenda was on this window over here, or if this place was locked after business hours, people couldn't access it, that likely would not be in compliance with the statute. It needs to be posted on an exterior door where members of the public have access to that even after business hours or even when that building is locked. So you mentioned you do have to have that one physical notice regardless of the type of meeting. If you have a online meeting, so a Zoom, a WebEx, a Microsoft Teams, a Google Meet, you also have a second posting requirement, and that's an electronic posting. So you have a Zoom meeting, you have to post physically at your principal place of business 24 hours in advance. You also have to post online. The statute specifically says your website, but a lot of smaller organizations, smaller PGBs don't have a website. They have a Facebook or they have an Instagram, which is a good alternative if you don't have a Facebook page. Include the date and time the notice and the agenda was posted. So on the bottom left-hand corner or right-hand corner, you're just noting the date and time you actually physically posted that notice. I know a lot of times within our office, we'll mail off we'll print off documents to be sent out that has today's date on it, but won't actually go in the mail until tomorrow. I always make a physical handwritten of the exact date it actually went out of the mail. So it's very helpful to do that with your notices as well. That way your custodian is not having to remember 6 months or a year down the road, hey, did I post that notice? Was it me? Was it somebody else? What time was it posted? What date was it posted? If you actually handwrite it when you actually do it, it saves you a lot of hassle later on. Include the name and contact information for your custodian. So on your notice or your tentative agenda, you're putting the contact information for your custodian so members of the public know who to reach out to. That way you cut down somebody calling your PGB, trying to figure out who the custodian is, calling multiple people. If you make that available to the public on that notice, it's a lot more transparent, it's a lot easier for everybody. And just be as specific as possible when drafting those tentative agenda items. Like I said, more detail is obviously better than less detail. You have less room for ambiguity if you're just as detailed as possible. Meeting minutes. So if you have a meeting, either open or closed, you must take minutes. Those minutes must include the date of the meeting, the time of the meeting, the place or location of the meeting, members present and members absent. And this is just members of your board. Say, for example, if this was a public meeting, we wouldn't have to take attendance on everybody in the room. It would just be on the board members. Those taking attendance of your board members must be by name. It can't just be 5 present, 4 absent. You actually have to say John Miller present, Tammy Miller absent. A record of all votes taken. Every vote taken in every public meeting, open or closed, must be recorded. Roll call votes must specify each individual member's vote. So in closed meetings, every vote must be a roll call vote, which means that the public must be able to attribute a vote with a specific person. So John Miller voted yes, Tammy Miller voted no. Or we list all the no votes and all the people who voted no, and then the yes votes and everybody who voted yes. Either one of those is acceptable. If those minutes are from a closed meeting, you need to cite which section of 610.021 authorizes you to have your closed meeting. And if applicable, the good cause to hold that meeting on less than 24 hours notice. That also applies if you're modifying your tentative agenda in less than 24 hours. It applies if you're having that meeting at a place that's not reasonably accessible to the public, or it's not of a place that is of sufficient size to accommodate the anticipated attendance. Anything that falls outside the normal requirements. Yes, sir.
You may come up to this later, but since you brought it up, is there some good examples on what would require a closed meeting without the 24-hour notice? emergency?
So we are gonna talk some about the 610-021 exceptions. And if I don't cover it there, circle back to me. And just with our notice and our tentative agendas, just be as detailed as possible again. It just cuts down on the ambiguity and the questions if you're just as detailed as possible in your minutes, just like you are with your tentative agenda. Closed meetings are usually permissive, they are rarely mandatory. There are some exceptions when a body has to have a closed meeting. Usually that's getting advice from your legal counsel. But for the most part, public bodies are authorized, they're not required to have closed meetings. But if you do have closed meetings, it must be because of one of the 26 reasons, that says 25, it's actually 26 as of last year, reasons why you can hold a meeting under 610-021. It's not just a best practice, but it is a requirement. All public business must remain open unless it is specifically authorized to be closed. Remember, everything's open by default, you have to have that legal reason to close a meeting. Liability most often happens for improper closure, not for over-disclosure. So generally speaking, you're going to get into more trouble for closing something that you shouldn't, as opposed to opening something that you're not really sure about. That's another thing I want to hit on real quick. The Sunshine Law covers if a meeting or records are closed and not supposed to be. It doesn't go the other way. So if a body releases something that somebody feels they shouldn't have released, that's not a Sunshine Law question. We've had people call our office making a complaint saying, hey, somebody made a Sunshine Law request with this public body, and they released all the emails that I've ever sent to that body with my name, my address, my phone number, and it's Sunshine Law, that doesn't fall within the scope of the Sunshine Law. So if they release something that you don't feel is appropriate, that's not a Sunshine Law matter. However, if they refuse to release something that is otherwise open, then that becomes a Sunshine Law matter. So I mentioned that there are 26 reasons under 610-021 about why you can close meetings, records, etc. These are some of the most commonly listed exceptions. So if the meeting is not contained in the 610-021 that we're looking at here, or within the other ones that are contained in the statute, because I said there were 26, it's generally not going to be a closed meeting. It's going to be an open meeting. So you'll notice that some of these have asterisks next to them. We refer to those as an evidence-based cutoff. So while a meeting or records might be closed for a certain amount of time while a matter is pending, the ones with the asterisk at some point, the records associated with those endeavors are going to become open at some point. And I'll give you an example. Under subsection 11 and 12, the bid process and sealed bids. So say a city or a county is taking in sealed bids to build a new police department or a new health department. They can take those bids in closed session. But once those winning bids have been unsealed, the winning bidder has been selected, land's been purchased, construction's complete, all the legal requirements for that particular endeavor are done, chances are the records associated with it are then going to become an open record. And when that happens, it's going to be a question for your attorney. Hey, somebody's made a request for the records associated with XYZ. Are these records open, or these records continue to be closed? And if they are continuing to be closed, the body needs to be able to articulate why it's continued to be closed with that endeavor being complete. Hit on personnel records. Subsection 3, hiring, firing, discipline, and promoting. So this refers to when a public body is taking action against specific employees. So you're firing your clerk, you're hiring a new public works person. This couldn't be, you couldn't use this exception if you were, say, looking at salary increases for everybody in your organization. It needs to be specific individuals that you're taking action against. Something I want to mention real quickly too, when it comes to votes. So votes in a meeting, whether it's open or closed, are public. So if you're taking votes in a closed meeting, the votes and how everybody voted for that vote is an open record. Even if the discussion about what you're voting on can continue to be closed, the votes themselves are an open record. The only exception to that is if a body is meeting under subsection 3. So say you're firing your clerk, or you're hiring a new public works person. If somebody makes a request for the votes associated with a meeting being closed meeting under subsection 3, the body can withhold the results of that vote for up to 72 hours. But in that 72 hours, they would need to notify who that vote was about. So say you voted to fire your clerk. And right after that meeting, I came in and said, I want to know who voted what way for those votes in closed session. The body could withhold the results of that vote until they notified the clerk who that vote was about before they released those to me, a member of the public. There's also a misconception that the body is required to post notice of that meeting with its tentative agenda. There's no requirement that they post minutes from a meeting. So you can request those minutes from the meeting, but a body is not required to post those minutes after the meeting. We recommend as a best practice they do so, but they're not required to post those meeting minutes. Only that notice and that tentative agenda is required to be posted 20 hours before that meeting. Subsection 14, prohibited from disclosure by law. I call this one the catch-all, because while we might have these 26 reasons under 16021 to close meetings, records, etc., there may be other laws outside the Sunshine Law that authorize or require meetings or records to be closed. And examples of that would be, say for example, HIPAA. HIPAA protects the confidentiality of medical records. Missouri has laws that protects the confidentiality of juvenile information in law enforcement records. Missouri protects the confidentiality of sexual assault victims. All of those three examples, there's no exception in the Sunshine Law for those, but laws exist outside the Sunshine Law. Another thing that came up not too long ago is blueprints. People requesting copies of blueprints for protected information. Blueprints, for the most part, have copyright protections, federal copyright protections. So if a body is going to close a record or meeting for a reason outside the Sunshine Law, such as they copyrighted blueprints, they would cite subsection 14 and then cite whatever law it is that authorized those records to be withheld. So if a body is going to withhold records or close records under subsection 14, simply stating they're closed under subsection 14, prohibited from disclosure by law, and just stating that is not sufficient. They do need to tell you what law it is that it's protected from disclosure. How to close a meeting. The statute talks about two different methods for closing a public meeting. So a public body may vote by an affirmative public vote of a majority of its quorum to close a meeting. So here you're in your open meeting, you're getting ready to go into your closed meeting. You have to take a vote, public vote on the record, roll call, to leave your open meeting and go into your closed meeting. One question I did get recently is, can we do one vote to leave open and go into closed, or do we have to take two separate votes? For example, do we have to vote to leave open and a second vote to go into closed, or can we do one vote that accomplishes both? That is up to you as a public body. The Sunshine Law doesn't require two votes, it only requires one. So if you're going to have one vote to leave your open session and go into your closed session, you can have that in one vote, not necessarily two. But if you wanted two votes, that's up to you as a public body. Only close a portion of the facility used for closing the meeting, and only discuss business that is necessary that justifies that meeting's closure. I put this little disclaimer in here because there was a court case that I came across when I was investigating a complaint. It was many, many years ago. In fact, I think it was actually in the 80s or the 90s, where a body had voted to go, they were going into their closed session. And as you know, sometimes people do when you get into a meeting setting, hey, what'd you guys get up to? What'd you do this weekend? There was about 35 or 40 minutes of personal discussion that had nothing to do with the reason they went into the closed session. Eventually, they went into their closed session, they had the meeting. Fast forward, where a member of the public wanted to gain access to the records of that meeting. They had no idea about the personal discussions that took place, but they wanted access to the meeting. But when the court looked at that gathering, they said, well, they closed the meeting under the correct section of 610.021. They posted 24 hours in advance. There was a tentative agenda. The records associated with that endeavor are going to remain closed. However, that 35 or 40 minutes of personal discussion that had nothing to do with why they closed that meeting, the court opened that portion of it. And during that 35 or 40 minutes, this body had voted to record its closed session, including those personal discussions. And some of those personal discussions were about these elected officials talking about how they felt about certain members of their community. And as you can imagine, some of those conversations did not go very well, and so it didn't turn out very well for some members of that elected body. So when you get into your closed meeting, stick to topic, don't deviate from it. Okay, any questions about closed meetings before we move into our closed records component? Yes, ma'am.
I have a question. If you're in a public meeting and you don't have that you're gonna be enclosed, but you have a personnel come in and it's involving like a legal issue and they're upset, can you go into an emergency meeting? Because you can't discuss what they need to with public there.
So in that type of case, you're gonna wanna look at the issue. Is this an issue that can wait 24 hours in order to be in compliance with the statute? If it can wait 24 hours, the best practice is to do so. But if you can't, it's like, nope, this is something we need to discuss right now, you still need to be able to post notice of that, so somebody would have to say, hey, we weren't gonna have this closed meeting, but now we are, and you need to articulate in your minutes why that meeting needed to take place on an emergency.
So like if you put that, real fast, like, hey, well, I'm sorry, but we're gonna have to go into closed session, and you put a meeting out on the board real fast, hey, emergency session had to go into because of this, whatever, does that work for it?
So I can't make a definitive determination on that specifically, but there is that exception for you to be able to do that. Now, whether you can do it in that specific situation, like depending on what's going on with that person, is something you're gonna wanna ask your attorney about. Hey, is this sufficient enough for us to go into closed session on an emergency notice, or is this something we should wait 24 hours to post notice of? Even if you're gonna go into closed session tomorrow, within that outside that 24 hours. So that's when your attorney's gonna make that judgment call. Yes, ma'am.
Does your attorney have to be at every meeting?
There's nothing in the sunshine law that requires that. If there's other laws or other city ordinances or something that say that they do, that's outside the scope of the sunshine law, but there's nothing in the sunshine law that says that. Yes, sir.
Can you put on your regular meeting notice, can you put the possibility of going into closed session on all of those? Or?
So that's come up in different trainings as well. It's generally not a good practice to, if you don't intend to go into closed session, to put it on there just as a catch-all. Because really, you're not intending to go into it, you're just putting it on there just in case. And that really wouldn't be reasonably calculated to advise members of the public of the matters to be considered. So I'm not going to advise one way or the other, I'm just saying that is not a best practice, to do that just in case. Yes, ma'am.
In a closed meeting, why would you take minutes of the discussion that was personal? I thought you were supposed to take votes that were cast and cast them. Why would you have all that in your meeting minutes?
So when you do have a meeting, you have to take minutes of what we talked about earlier. That's what I'm saying, if you're having personal discussions, you shouldn't be having personal discussions to begin with. But somebody was probably just trying to be extremely thorough, and that, you're talking about the case that I mentioned earlier with the elected officials, that was a recording, it wasn't even in their minutes. They decided to record it, and they kept that recording, and then when the lawsuit got filed, when a lawsuit's filed, it's called preservation. You're not supposed to destroy anything associated with that lawsuit. So they kept that recording, and that's how come all that information came out. It wasn't written in the minutes, it was just a recording. Well, I'm assuming so, I didn't review the minutes, I just referenced the audio recording. Any more meeting questions? And by the way, once our presentation's over, I'm gonna stick around in case somebody has more questions, or some people don't like asking questions in front of everybody. So Brandon and I will stick around if people have questions they don't wanna ask in front of everybody. So don't feel compelled to ask a question in front of everybody. Yes, sir.
Is it better if you're having your meeting and you know you're gonna have a closed meeting, to do that at the end of your meeting, like after the close, then it probably be adjourned, instead of doing it like beginning of the meeting or?
Really, there's nothing in the sunshine law that says one way or the other. That's up to you as a body. If you want to have I've seen some organizations or public bodies that have their closed meetings first and then their open meeting, because not everybody who's in their closed meeting is going to want to stay for the open meeting. And I've seen it the other way around, where open meeting is first and then closed. So basically, it just depends on what works for you, as long as you comply with the requirement of those votes to vote to go into your closed session. It's up to you.
You can go closed, back open.
Yeah. In fact, I've seen some bodies that will go into closed session to discuss something, and then they come back into open session to do their votes, and they just do their votes publicly, since votes are open to everybody anyway. So, again, up to you as a body. So what is a public record? So the Sunshine Law defines a public record as any record, whether written or electronically stored, that is retained by or of any public governmental body. And the courts have construed records very broadly. It's been written records on paper, it's been electronic records in emails, it's items held on a thumb or a flash drive, And it's even been older forms of records, VHS tapes, cassette tapes, those little mini cassette tapes they used to use way back in the day. I know that in our public safety section where I used to work, we have a lot of old homicide cases where a lot of the depositions and the interviews are all on VHS tapes. So those have actually been held to be records as well, even if they're older forms of records. So what records must be retained? We get a lot of questions about, do I have to keep this record? And if so, how long do I have to keep this record? That's actually not a sunshine law question. That's a records retention question under a separate chapter of Missouri law. That's actually chapter 109, which is under the purview of the Secretary of State. Our office actually doesn't have any authority over records retention. So if your question is, do I have to keep this record, and for how long do I have to keep this record, you're going to want to reach out to the Secretary of State's office. They actually have all of their records retention schedules online that says these documents you have to keep for this amount of time. But if your question is, is this meeting open or closed, is this record open or closed, then that's a sunshine law question. Electronic transmission of public records. Always remember that as a general rule of public records, any record, whether written or electronically stored, retained by or of any public governmental body, is considered a public record. So say I send an email to Brandon to his AGO email from my AGO email, and I say, hey, I'm running out to Subway to go grab a sandwich. Do you want something? It has nothing to do with public business, but because I sent it from my government email to his government email, and our agency retains it as part of our records retention policy, if somebody made a request for that email, we would either have to provide it, or we would have to state why it was closed under the sunshine law. So just because a record has nothing to do with public business, if you retain it, it's considered a public record. Also under 610.025, an electronic record may be considered a public record if it is sent to a quorum of officials, which includes the sender, and it relates to public business. So if you're sending emails back and forth to your entire board, which includes you as the sender, and you're discussing public business, that's when you're required to keep those communications. For how long you're required to keep those communications are going to depend on the communication, and that's when you're going to want to talk to the Secretary of State's office for records retention issues. But if you're discussing public business and it's to a quorum of your board, then you are required to keep that. The message meets the above requirements. Best practice is to send to the board members or the member's government-issued email device, issued the device or the custodian of records. Each member of a public governmental body should have a government-issued email account. Is anybody here using a Gmail or a Hotmail or an Outlook.com to conduct public business? Okay, so if you are, it's best practice we understand that not everybody can have a .gov or a government-issued email account. It's best practice to have a separate email account devoted specifically to your public duties. You don't want to be in a situation where you're using your personal email to conduct public business and you have public records and your private business in that one email. So far, there haven't been any court cases that have said, well, there's a public record on your personal email, so your personal email is now public. But because it's still happening so frequently in Missouri, you don't want to be the person who the first person is like, well, now they have access to my personal email because a government document has to be in there. So if you're conducting any type of public business from a Gmail or a Hotmail, either forward those communications that deal with your government business to your custodian, or have a separate email account that doesn't intermix with your personal. Another question I get recently is cell phones. If you have a cell phone that is issued by the public body, generally speaking, that is a public record. However, if you have a personal phone, it's your personal phone, even if the public body is giving you a stipend for that phone, that generally, there haven't been any cases that have said that is a public document or public record. Only if it's a situation where that device is issued by your public body, then that would be considered a public record. So basically the synopsis of this is, don't intermingle your personal with your professional on your email. Always keep them separate. You don't want to get into that kind of situation. Yes, ma'am.
So what if you have your personal phone, but you get your business email?
So it's your
I have,
your government issued email is just on your phone. So
just where I can.
just look at it.
Yeah.
So that's probably a situation where your emails are already retained
Right.
by the public body, you just have another way of accessing them here.
So that doesn't mean my files.
Right, as long as your public body has it. Yeah. Yeah, I get that question a lot too, so. It would just be if it was your personal email and you were getting government emails to your personal, okay. So submitting an open records request. So a requester could submit a request for records a variety of ways. They could do it by letter, they could do it by email, they could do it by phone call, or they can do it in person. The Sunshine Law actually does not require a specific submission method for submitting a records request. So while you can request that a member of the public use your form, you cannot require them to use your form. However, I would absolutely recommend to people who are looking to put in a records request, do it by email if you can, or do it in writing. And the reason is because if you don't, I want to give this over the phone, I want you to take the request down, I don't want to put it in writing. And then 3 weeks later, I've had this happen, the person will call me and say, hey, I put in my records request 3 weeks ago and nobody's gotten back to me. And I said, okay, who did you speak with? I get the information, I'll call that clerk. That clerk tells me, I have no idea who that person is, I've never talked to him in my life. It becomes a he said, she said kind of situation. So it benefits you as the requester to put it in writing, because then that 3-day window starts, you have now a written record of it being submitted. It's cleaner for everybody if you just do it that way.
Question.
Yes, ma'am.
When someone requests a copy of the reports or the minutes, can you charge for the copying and the time to get the copying done?
So the Sunshine Law allows you to charge up to 10 cents per page, and the hourly salary for the lowest clerical employee within that organization. So if somebody makes $20 an hour and it takes you 15 minutes to get that, then you can charge $5 plus that 10 cents, however many pages it is, to get that record. So a public governmental body must act on the request as soon as possible, but no later than 3 business days after the custodian receives it. So say you're the custodian of records, and somebody sends a records request at 4 p.m. on Friday, and you went home at 3 p.m., so an hour before. You come in on Monday morning, you go get your coffee, you go get a donut from the break room, and you open up your email about 10 in the morning on Monday. When does the first day of that 3-day business days start?
Friday.
Monday? Anybody else?
Friday at 4.
Friday?
Monday.
At 10?
So the first day is actually Tuesday, close of business Tuesday, because it's the first day following receipt. The statute actually says you have to provide a response the 3rd day following receipt. So if you received it on Monday, the 3rd day following receipt would be Tuesday, Wednesday, so Thursday. So that first day would be Tuesday. Now you obviously shouldn't be using that as an excuse to circumvent or getting around responding to Sunshine Law requests, but it does give you a little bit of a leeway. Also, something that I didn't mention in our last training, but somebody actually asked it as a question afterward. If you're the custodian and you're going to be out of the office for more than a day or so, it's best practice to have somebody being as a backup custodian. You don't want to get into a situation where you're out of the office for days or weeks and nobody's responding to those records requests. So definitely have a deputy custodian if you're going to be out of the office. And that 3 business days that I just talked about with the day starting Tuesday actually comes out of this court case here that was decided in 2021. Starr versus the Jackson County Prosecuting Attorney's Office. Address your request to the custodian of records by name or by title. In this court case, somebody had actually submitted a records request to the Jackson County prosecutor. And the prosecutor was actually responding to the request, they were providing the records, but at some point something fell through the cracks. The person did not get all of their records. So the person ended up filing a lawsuit. And when the court looked at that particular request, they noted that the custodian for the Jackson County prosecutor was the prosecutor herself. And she never even saw the records request until the lawsuit was filed. So the court held that that records request was not received by the custodian, and thus there was no violation. So when you put in your records request, make sure you put it in to the custodian by name or by title. It's best to know specifically who that individual is, so you can address it to them individually. Phrase your request with specificity using language that a reasonably competent custodian of records would understand. A custodian of records, a public body, needs to be able to know what you are requesting in order to provide records pursuant to your request. Give me all your emails. It's a very broad request. There's no dates, there's no names, there's no titles. So if you get a request like that that's overly broad, best practice would be for you as the custodian to reach out to the requester and say, hey, you said give me all your emails, but you didn't give me any dates, you didn't give me any names, you didn't give me topics. Can you please narrow this down for me? And that's good for a couple of reasons. One, you might not be searching for records that you don't need to be searching for. Two, especially if you charge for records, the person might not want to pay for records they don't want. And if our office is looking into a complaint and we can easily tell that the body has tried to do its due diligence, they tried to reach out to the requester to narrow it down. We've had situations where we've reached out to a body for a complaint and they said, well, we didn't know what the requester was asking for, so we didn't even respond. That's not something that you can do as a public body. So try and do your due diligence. Include the fee, so if you're searching for those records, try to include a fee estimate in that 3-day response letter. Requested format, in-person access, paper copies, electronic copies. Try to establish that on the outset so you know which way the requester wants those records provided to them. If you can provide records in a particular format that the person requests and you are capable of doing that, you do need to provide the records in the manner in which the person requests. So if they want electronic copies and you are capable of doing that, you have to provide the records in that format. If they want physical copies on paper, you have to provide the records in that format if you are capable of doing that. But this is also a situation that, the example I gave, give me all your emails, is a request I got when I was at the AG's office. And so I reached out to the person, I narrowed it down, I figured out what they were wanting, and at the end of the day, it was still about 6,000 emails this person wanted. And this person wanted these emails printed. They did, I was like, can you give these electronically? Nope, I want paper copies. Okay. So our IT people were able to narrow down what these records were, and again, about 6,000 emails. They were reviewed for privilege, they were redacted, the specific section of law that authorized to redact was all included. But before we produced them in that physical form, we calculated what it was going to cost to produce those records in physical form, so that 10 cents per page. And as our custodian is standing there printing everything out, that's cost that could be put back on the requester. And the fee portion of the Sunshine Law was not meant to be profit generating, and it wasn't meant to discourage members of the public. It was meant to recoup the fees in order to produce those records. And so at the end of the day, I said, well, I can go buy a $15 thumb drive and you can have your records at the end of the week. Or if you want them in physical form, it'll be, I think it was something like 6 weeks out for that. And it was several $100s. At the end of the day, the person ended up getting the records electronically. But if the person insisted I want them in physical form, we would have had to provide that to the person in the manner that they requested. We could have charged for that, but they didn't at the end of the day. You have a question, sir?
Yeah, when you had your IT people break down the emails, you could not charge for their time?
No. No, because it's you have to charge, well, you could charge, but it would be the lowest salary employee. You couldn't charge your IT people staff. And you also can't charge for your attorney to review, to redact. If they were gathering up that information, yes, you can charge for that, but the review time to be able to redact that information cannot be charged. And that was actually established in the lawsuit against the governor's office, Gross v. Parson, where they were charging the attorney's fees for the redaction of that stuff, and the court held that you can't do that. So the research part of it you can, but the redaction of your attorney's fees, you can't charge for that. And another thing, say for example, your clerk makes $10 an hour, and that's the lowest salary person within your organization, it's the clerical staff, but she's gone one day, so your administrative assistant who makes $25 an hour is going to be searching for those records. You can't charge that $25 an hour. You have to charge that $10 an hour, even if that person who makes $10 an hour was not the one actually doing the research. Responding to open records requests. The public body must act on the request as soon as possible, but no later than 3 business days after the custodian receives it. So if you can provide those records within those 3 business days, absolutely do so. But if you can't, you not only need to provide the person with the reason why you can't provide those records within 3 business days, you also have to give them the earliest time and date that the records will be available for inspection. And Gross v. Parson also established in that lawsuit against the governor's office that the governor's office's practice was your records were ready on Thursday or a week from Friday. And the court said that was not an acceptable response to earliest date and time. You have to give them a hard, fast date and time. So your records are ready on Friday, December 31st at 3 p.m. You can always extend that date out if there's a cause for delay, which you have to explain to the requester, but you do have to give the requester a hard, fast date and time. Simply stating your records are ready next Thursday is not sufficient for sunshine law purposes.
Can you say your custodian was on vacation?
If that really shouldn't be the only person that's capable of doing that search. There should be other individuals who are following up. And if it's something that they're only office for a day or so, that's one thing, but if your custodian's gonna be out for a week or more, there needs to be a backup custodian so those records are not. Let's see, address any fee estimates in that initial response letter. So try to calculate approximately how many records are gonna be responsive in that 3-day letter to the requester, so they know approximately how many, what that charge is gonna be. Try to do your initial search. A lot of times our office, like we have a lot of physical records and we have a lot of electronic records. So when somebody makes a records request, we have to search both of those in order to be determined what is responsive and what's not. So try to do that when you send out your 3-day letter. All employees should know the identity of your custodian of records, and employees should forward records requests to the custodian. So if they say, for example, you're not the custodian of records and somebody makes a records request to you, best practice is to forward that request to your custodian and include the requester on that. That way all 3 of you are on the same page. Your custodian now knows they have a records request they need to do. It's off your plate, so you don't need to do it, handle it anymore. And the requester now knows who to go to for their records request. Records can be held in more than one location, especially electronically, so make sure you do that digital search. Contact the requester in writing, just how we recommend that requesters put their request in writing. It's also beneficial for the public body to keep a paper trail of their efforts. That way, if a complaint is filed and we reach out to the public body, they have a record of exactly what they were doing for that records request. We've had situations where they say, well, we didn't keep anything, we were just doing everything vocally, and there's no way for them to prove that they were actually doing what they said they were doing. So paper trail is always the better plan, just like it is when submitting a records request. Note the day the initial 3-day response went out, so like you did with your notice with that handwritten date and time, do the same thing with that 3-day letter. Because like I said, you may print it off today, but not put it in the mail until tomorrow. So if you have that physical notation, you actually have a hard, fast date and time of when you actually sent that out. Confirm the body's understanding of what is being requested and engage with the requester to clarify any possible fees. Confirm the way the records are going to be produced. It's better to do that on the onset rather than on the outset. And again, be very specific when explaining the reasons why those records can't be provided within those 3 business days. If there are no records responsive to a request, the body still needs to let the requester know. We've had situations where the body said, well, we didn't have any records responsive, so we didn't even respond. It's not something you can do as a public body. You do need to provide them a response, even if it's to tell them, hey, we don't have any records responsive to the request. Redact whenever possible instead of closing an entire record. There's actually a section of the Sunshine Law at 610.024 that states that if a record has both exempt and non-exempt information, you can remove the exempt information, but you do have to provide the non-exempt information. So say, for example, you have a piece of paper that just has a social security number on it. You can redact the social security number and provide the rest of the record. You can't just withhold the entire document just because it has that social security number on it. Obvious reasons for closure, such as work product, we encourage you to state on the document. That way your custodian is not having to remember a year or 2 years down the road, is this closed? What was this reason it was closed? It's stated on the document itself. This is another area we get quite a few complaints on. The Sunshine Law does not require a public body to create a new record upon request, but only to provide access to existing records that are held or maintained by the body. So I'll give you an example. Say a public body decides to have a Christmas party and they rent out their community center. And people are coming and going from their community center, members of the public, hundreds of people. And then a couple of days later, somebody says, I want a copy of the sign-in sheet for that event. Well, if you didn't keep a sign-in sheet, if you didn't take one, you're not required to go back and recreate a sign-in sheet in order to provide it. However, if you did keep a sign-in sheet, it would likely be considered a public record and you would have to provide that unless it was otherwise closed. But if you didn't take one to begin with, you don't have to go back and recreate it in order to provide it. The same provisions of 610.021 apply to closed records as they do to closed meetings. That also includes that subsection 14. If you're going to withhold records for something outside the Sunshine Law, you have to cite subsection 14 and then whatever law authorizes you to. If records responsive to a request are closed, provide a response that generally describes the material being exempted unless that description would reveal the contents of the exempt information. So here you're kind of treading a thin line trying to describe what the closed records are without going into too much detail. So it's kind of a thin line that you're walking. Redact whenever possible instead of withholding the entire record. We covered that. That's 610.024. Best practice when closing records, provide information to the requester about what documents have been closed in the final response letter. So if you're closing or redacting information, you can't just state, well, these are closed pursuant to 610.021 without stating a subsection or a specific area of law. Because if you do that, if you just say, well, these are closed pursuant to 610.021, the requester can come back and says, well, you didn't provide me a specific section of law that authorizes you to do that, which means the Sunshine Law now gives you a new 3-day response time to provide that information to them. So if you're closing records, if you're redacting records, state the specific section of law that authorizes you to do that. That way you save yourself from a new 3-day response time under the Sunshine Law. Okay, some final thoughts. When in doubt, a meeting or record of a public governmental body should be open to the public. So if you're in a situation where you're not sure whether you should close something or not sure if you can open it, the scales tip on the side of transparency and openness. The Sunshine Law applies to all records, regardless of what form those records are kept in all meetings, regardless of what manner those meetings are held. The Sunshine Law allows a public body to close meetings and records to the public in some limited circumstances, but it rarely requires a public body to do so. Except in emergency situations, a public body must give at least 24 hours public notice before holding a meeting. If the meeting will be closed to the public, the notice must state the specific provision or multiple provisions of 610.021 that authorize that meeting to be closed. So if it's closed, subsection 1, legal, subsection 3, hiring and firing, subsection 13, personnel, make sure you state that subsection. So when you're closing a meeting, it's not acceptable to just say, this meeting is closed pursuant to 610.021. You do need to state that subsection. Each public body must have a written Sunshine Law policy and a custodian of records named by law, whose name is available to the public upon request. The Sunshine Law requires a custodian of records to respond to records request as soon as possible, and no later than 3 business days after the custodian receives it. Remember, just because it was sent doesn't mean it was received by the custodian. When responding to a request for copies of its records, the Sunshine Law limits how much a public body can charge per page and per hour for copying and research fees. Those fees are 610.026. There are specific provisions governing access to law enforcement and judicial records. The judicial records are that Missouri Supreme Court Rule 2 that I mentioned. And law enforcement records are 610.100, and that's going to depend whether the records are an active investigation, an inactive investigation, whether charges have been filed. And if your law enforcement agencies are interested in a specific law enforcement training, our email address is at the end of this presentation. We do a presentation specifically for law enforcement as well. The Sunshine Law allows for open public meetings to be both audio and video recorded by attendees. Each public body may set up guidelines regarding the recording process. Those guidelines should be included in your Sunshine Law policy. Remember that no one is allowed to record a closed meeting unless they are given permission to do so. That's where we recommend that if you're going to record your closed meeting, you take a vote on the record to specify who's going to be recording and by what method they're going to be recording, so it's in your minutes. The Sunshine Law deals with whether a public body's records are open to the public, but it generally does not state what records the body must keep or for how long. That's a records retention question that you want to talk to the Secretary of State. So I won't go through every one of these, but basically our office is not the only office that's responsible for Sunshine Law compliance and enforcement. The state auditor is as well. And when they go out and do audits of public governmental bodies, they also do a Sunshine Law audit. And these are some of the most common potential violations that they've come across in their reviews. We have tried to incorporate all of these into our Sunshine Law presentation to try and cut down on the potential for future violations with public governmental bodies. And that concludes the presentation. Do we have questions? Yes, ma'am.
You did all the talking about the custodian. On your records, do you have the people present, do you have to list the person's name and give them a title of custodian? Or how do the people know that this is my custodian on the records?
So in your policy, you should state who your custodian is, for one. And on that notice, when we say put the custodian's name and contact information, that's not required to be on that document. It just helps you. It's much more transparent if you say Jane Doe, custodian of records, contact her at this number or this email to request copies of public records from our public book. Yes, ma'am.
What are acceptable methods of recording votes? Can you, of those present, if it's unanimous, can you just say unanimous? Can you say these three people said no, the other said yes? Or do you have to list all of them?
So generally speaking, you should list everybody's name and how they voted, because that's what the statute requires, a roll call vote. Again, there haven't been any court cases that we're aware of that says that saying, it's unanimous, but because there can be, people there, people not there, it's better to list everybody by name and how they voted just for clarity. Yes, sir.
You were talking about the voting during a closed session is still open to the public. Do you just, if the subject is, it can't be talked about, how can the vote be?
That's just the way the Sunshine Law defines it, that the vote is an open record, but what they're discussing about is a closed record.
You just showed 3 people voted yes or 2 yes and 1 no, but it doesn't have a subject, it just lets you know what they.
Well, for example, we've seen one where there was one closed under legal, there was a lawsuit going on. It was John Doe versus Smith. And somebody made a request for the results of that vote, and it's like there was a vote in closed session, John Doe versus Smith. These 5 people by name voted yes, these 3 people voted no, even if the details about that vote are not public, but the vote itself is.
All right.
But the subject is. True. At a closed meeting, if you have, like what you just said.
Yeah.
The subject is, and the vote is, but not the discussion.
Right, correct. It was legal, or it was personnel. It was a vote to fire the clerk or hire a new public works person, or it was a bid process vote, or whatever it was.
So the motion would be public, the motion that they were voting on.
Correct, even if the subject details were not public. Yes, ma'am.
Can you require a deposit if you know the records they're requesting is gonna be a large sum? And say like, this is an estimated cost and we'll give you a breakdown, but we would like this before we pursue?
So that's actually pretty interesting about that, is that the Sunshine Law only allows a advance fee to be taken for copies. It's 610026, I think it's subsection 2. So if somebody is requesting, if they requested records and they want them in physical form, so they want 50 copies, you can request that 10 cents per page up front before you start producing those copies. But say like they wanted those electronically, there's not gonna be any physical copies, then you can't request an advance fee because there's no actual copies. The statute specifically says copying fees. However, when they come to pick up their records, then you can require them to pay the full amount before they actually take possession of those records. But the advance fee can only be for copying fees. Yes.
Do you have to, I don't know, keep the agenda for all the meetings, you should keep those, right?
You should. For how long is a Secretary of State question? But yes, you should keep
What about
those.
the written minutes? Because we have to type them up and keep them.
Mhm.
What about the written minutes? Keep them, or once they're typed up?
Like your notes for being able to take. Again, that's a question, that's up to you whether you want to keep those minutes, as long as there is a record of that meeting in the minutes. What additional information you include with that, your draft notes or whatever else, is going to depend on whether you're required to keep those. We talked about this at our last meeting, our last conversation with the Secretary of State's office is that as long as there's a set of minutes, then there's really not any requirement. It's definitely a best practice to keep that additional stuff, but there's not necessarily a requirement to if you already have the minutes, which is what the statute requires. Yes.
Okay, committees are formal versus informal. So what if you've got a board that wants to have some research done outside and 1 or 2 board members, not a quorum, agrees, I'll put something together so we can look at it at the next meeting. Is that
So the sunshine law doesn't make any distinction between formal and informal, so a committee is a committee. If they've appointed a committee and they've established this many, there's 5 people on this committee, 3 constitute a quorum. If those 3 get together, if 3 or more get together to discuss any kind of public business, that is considered a meeting and should be noticed properly. If there's less than that quorum and they're just gathering up, they're getting ideas, they're going to get stuff, that's probably not considered a public meeting unless they are meeting with less of a quorum in order to circumvent the sunshine law. So intent is important as well.
But at some point, people have to get information in a format to present to the board.
Right.
Yeah.
Yeah, but you can do that, I mean, if you can meet in smaller groups, but if it's all about your intent. If you're getting together just to kind of facilitate things to go quicker, that's one thing, but it's like, hey, let's just meet the 2 of us so that we don't have to notice a meeting. That's when you get into that area where it could be your intent is to violate the sunshine law, and you don't want to get into that area. So that's why best practice is always to err on the side of caution and do a public meeting just to be on the safe side.
Can you talk about draft minutes as in unapproved yet minutes being public records?
So there is actually a court case, it's Al versus the Missouri Advocacy Services. I don't remember the defendant's name, but I remember the plaintiff's name was Allen. And that court case held that there's nothing in the sunshine law that requires a record to be in final form in order for it to be a public record. So if you have your draft minutes that you've prepared and you just haven't given them to the board to be approved, those draft minutes are considered a public record. And if somebody requested them, unless they were otherwise closed, you would need to provide those to the requester. And so what our office recommends that if you do have those draft minutes is watermark it or other kind of notation on it that says, these are draft minutes, these are not final form, so that when the final form does happen, there's no confusion about which are draft and which are not. But draft documents are generally considered public record if you retain them. There's nothing that requires them to be in final form in order to be considered a public record. Yes, ma'am.
Let's say we have an agenda, and I walk in after I get off work and walk in and say, I've got a problem, and they call on me even though I'm not on the agenda.
So there's kind of 2 ways this can go. One, if we're referring to a public comment period, there's nothing in the sunshine law that covers a public comment period. So a body potentially doesn't have to allow the public to speak at a public meeting. But if you're just walking in like, hey, I've got this problem, if it's something that is going to need to be discussed in the meeting that needs to be addressed right then and there, then that emergency or short notice exception will pop in. If it can wait, then the board says, well, let's wait to discuss this. And if you're just asking a few questions here or there and they're giving you a few answers, that's very different than them actually conducting public business where they're making public decisions without having it on the 10-minute agenda. That's where the danger comes in. Yes?
Are, your security cameras at Lake Sunshine?
If the security footage is retained by the public body, then yes, those are generally considered to be a public record.
It records over every 72 hours, so we don't really keep it unless something happens or pull it off,
So whether or not you're required to keep those is a records retention question. I don't think those security cameras, I don't think the Secretary of State covers those. So that's probably more of an internal policy about how long you retain those. Because if those automatically record over each other after 72 hours, if I make a request of something that happened 96 hours ago, then you no longer retain that record at that point.
For instance, like if I'm the custodian of records and I have a request for a copy of our planning and zoning manual. For sunshine law, I can only charge so much, but in the ordinance, they say it's $100. How does that work?
So the sunshine law, local ordinances can make things more accessible, but local ordinance cannot override sunshine law. It's state law. So if you are charging more than the sunshine law allows, you can't do that. So if it says you can charge 10 cents per page, but the city decides, well, we're going to pass an ordinance that is going to charge 50 cents a page. I'm not making a legal determination, but I'm saying that would probably be a lawsuit that you probably wouldn't win. There are actually, I think it's the recorder. There are specific laws that in court cases that have held that recorders can charge a certain amount more, but that's only because there's a state statute that says that they can charge more. In fact, it's actually, there's a section in the Sunshine Law that says, and I can't remember exactly where it is, but it states that if there's another statute that authorizes something different than what's in these minutes, or in these statutes, that's authorized. But that's state statute, not municipal ordinances. Municipal ordinance can't override state law, cannot override state law.
Are we talking, when you say custodian, are we talking clerk for our city hall or whatever it is we have? When you say custodian's going to be gone for a while, is that our clerk that is at our office all the time?
So it's up to you who you choose to be your custodian. There's nothing that says who the custodian must be. That's up to the public body as long as you have a custodian.
Okay, let's say that, can a
Alderman?
yeah, an alderman, can they substitute the custodian, even the board member is a paid member? Can they go in and answer phones, or if that individual is not out of the office?
So there's nothing in the Sunshine Law that talks about that. But if your custodian is going to be out of the office, somebody should really be filling in for them, so you don't have public records requests piling up in your office. But who that person is and who the backup people are, person or backup people, is a decision you guys have to make. Yes.
I know it's redundant, but first, the custodian has to be named or just a position?
So there's no differentiation. The Sunshine Law doesn't state how that person has to be named. There are some organizations that will say, in their Sunshine Law policy, it says, John Doe, city clerk, is the custodian of records for our public body, whereas other organizations will say the city clerk, whoever that person is, serves as custodian. So, and it's easier to do it the latter, because that way if John Doe leaves, you have to go in and change the policy to the new clerk, whereas if you just say it's the city clerk, when John Doe leaves, the new city clerk comes in, they're automatically the custodian. So it's a lot cleaner doing it that way, I think.
So another question, on the closed meeting, the custodian stays in closed meeting, or they leave the closed meeting, and someone takes over?
So the custodian for the body is different than who's taking notes in minutes. There's nothing in the Sunshine Law that determines who has to take minutes. That's up to the body who is, designating whoever to take minutes in a meeting. And that can be anybody, the body decides on that, as long as somebody is taking minutes in that meeting, which can be different or the same as your custodian of records. They're two distinct individuals, or responsibilities, I should say. Did I not explain that?
Yes.
Okay. But yeah, so you have to have a custodian, but who takes notes in a meeting doesn't have to be the custodian of records. It can be anybody that,
They can be the custodian and the minute taker.
Correct, they can be, but it's not required that they be the same person. The body, the board is the one that designates who the minute taker is. I mean, multiple people can take minutes, but there should be one person that these are the official minutes. You can take all the notes you want, but this person is the official minute taker.
How does that work in a closed session if you're discussing a legal issue? So if it's not the custodian of record, just say it's a secretary of another division, how does that work? Or if you're discussing personnel issues?
So the board, whoever's holding that closed meeting designates who takes those minutes.
So it doesn't have to be the custodian of record?
No. No, they can,
Would that be a violation of that person's personnel rights if it's just somebody that is not, like if, someone said, she's working for a department, I usually take the minutes, but I can't, and they're having a personnel issue with this person. So they designate this person to take those minutes. Is that not a violation of that person's rights?
that could be, but that's not a Sunshine Law issue.
That's not.
That's another civil or whatever issue. So I would say that if that's the kind of situation, you would not want somebody taking minutes, that would there be a conflict of interest in that meeting. So if your normal records taker is involved in whatever issue you're discussing, again, not a legal conclusion, but it's probably a good idea for the board to say, okay, you normally take minutes during this meeting, but because you're involved in whatever this is, we're gonna excuse you and have so-and-so take minutes for this meeting. That's within the purview of the board to decide who takes the official minutes. A lot of people, I've got a lot of questions, well, it's the city clerk, and the city clerk has to be in that meeting to take minutes. There's nothing in the sunshine law that requires that. The body itself decides who is going to be the official minute taker. Any other questions? Yes, sir.
The body also decides how detailed the closed session minutes need to be.
Well, we covered what was required in the minutes. Anything outside that, we recommend you be as detailed as possible, but as long as you have what's required under the sunshine law, then you're meeting the requirements of the statute. Did I answer your question? Remember, more detail is always better than less detail.
All records are public no matter the location, right? So like, we have city halls and we have people down across town in a different building, but they're still city personnel. Now, their records are still public records.
If the records are retained by the public body, it doesn't matter where those records are held. If they're retained by the body, they're considered public records for sunshine law purposes. And they're presumed to be open unless there's a legal reason to close them.
What about if you got 6 people in a council meeting and all the 6 people are taking different notes on different things that you're discussing? What do you do with those?
The body should establish who's taking the official records for that meeting.
So you shouldn't write down bullet points for yourself.
I mean, that's up to you if you want to do that, but just remember that document, even though you're taking it for yourself, might become a public record. So it might be added to the minutes at some other time. No, it's a good question, it's a good question.
So you should have only one official note taker.
There should be, you don't want to get in a situation where you have multiple minutes as the official minutes, it should be one person. And if you want to add everybody else's notes to those official minutes, but there should just be one official set of minutes for a meeting, whether it's open or closed. Anybody else? And I will stick around for a little while afterwards if somebody else has any questions they don't want to ask in front of people, so. All right.
Jay Brandon, thank you for coming out today.
Thank you.
It's a good day for government transparency in Northeast Missouri today. 50-some here, 75 in Edina. A great day for, 125 public officials. Learning a little bit. It's a terrific day. These guys are gonna stick around and, answer some questions for you. Thanks to Northeast Power for this great facility. Thank you guys. One of the surveys, drop them on the table back there. We'll pick them up. And if you didn't sign in, find a sign-in sheet. We'd like to know who was here. And other than that, thanks so much for coming, everybody. Have a great day and a safe trip.